All right, we will.
Good afternoon. Good afternoon, Mr.
Please
President.
be seated.
ushobora kwicara.
Well, Mr. Kabuga,
Perezida
we will start
Bwana Kabuga,
all over again. Can you hear these
tugiye
proceedings
gusubukura
in a language that you understand?
turashaka gusubukura utubwire niba ubyumva mu rurimi rwawe. Ese ibivugirwa ahangaha urabyumva mu rurimi rwawe?
The accused, yes.
Thank you.
Urakoze.
Now, I am hearing both my own voice and the interpretation in Kinyarwanda, so there is still something wrong with the system.
Ko hakiri ikibazo cya tekinike kigomba gukemurwa.
But it says plainly on the screen, Channel 4 English. But I'm hearing Kinyarwanda interpretation.
Ko icyongereza
So I'm looking to the clerk to tell me, do we need to leave the court again, or can this be resolved?
Your Honors, the technicians are looking into it. If you could kindly bear with us for a few minutes, we will address it.
Yeah, my Kabuga. Makomaja munyowe. Ndabona abantu bose mu rukiko ariko nabo bose. None ndakoreshe.
I'm not getting any interpretation of that either.
I can see that there are many people in the courtroom.
So Ram, does that look?
Mr. President, this is the Kinyarwanda booth. I'm interpreting from Kinyarwanda into French. I assume that there will be a relay from the English booth. That's why you can't hear me.
So what is the solution?
If there is an English booth, they can take a relay from the French booth.
There is an English booth taking a relay from the French booth, yes.
Well, I'm now only hearing English, so it sounds as though that may well be resolved. So I'm going to continue in the hope that it has been resolved. Thank you, Mr. Kabuga, for confirming that you can follow the proceedings in your language. May I now introduce the case?
Répète.
I am Judge Ian Bonamy, the presiding and pre-trial judge of the trial chamber assigned to this case. My colleagues on the trial chamber, Judge Graciela Susana Gatti Santana on my right and Judge Elizabeth Ibanda Nahamya on my left, are also here with me in court. I now turn to the parties. May I now have the appearances of the parties? First, the prosecution.
Good afternoon, Your Honours, to everyone participating also remotely. I'm Rupert Elderkin, and with me today for the prosecution, Ian Reid, Laurel Begg, and Barbara Goy.
Thank you, Mr. Elderkin. I note your appearance and welcome you as one of the senior trial attorneys prosecuting this case. Now, counsel for Mr. Kabuga.
Good afternoon, Your Honor. Good afternoon, Your Honors. The defense team includes Mrs. Nauri, Professor Jacobs, and myself, Emmanuel Altit, lead counsel.
Pleased to note the appearance of Mr. Altit, who I welcome to his role as defense counsel here at the initial appearance. I would like to start these proceedings with a brief overview of where we stand before receiving submissions from the parties. Mr. Kabuga was arrested on the 16th of May 2020 in France and transferred on 26th October to the United Nations Detention Unit at the Hague branch of the mechanism for a detailed medical assessment in view of his age and concerns raised by the parties and the registrar about the ability to safely transfer and detain him in Arusha. Mr. Kabuga's initial appearance took place in person on the 11th of November 2020, and I entered a plea of not guilty on his behalf pursuant to Rule 64A4. Due to stringent lockdown measures and travel restrictions imposed by the Netherlands to combat the spread of COVID-19, the in-person status conference scheduled for the 3rd of February 2021 was postponed. Ultimately, with the agreement of both parties, a status conference was held by way of written procedure. That status conference was concluded by an order from the trial chamber on 6 April 2021. The principal areas of litigation in the case have so far concerned the indictment, disclosure, and access to confidential information from other cases, matters related to representation and the health of the accused. Looking at the indictment, on 24 February 2021, the trial chamber granted the prosecution leave to amend the indictment, to update the allegations and the pleadings in view of developments in case law and available evidence. In that decision, the trial chamber maintained Mr. Kabuga's plea of not guilty to the charges. Unless the trial chamber hears otherwise today, we intend to maintain the not guilty plea. The amended operative indictment was filed by the prosecution on 1st March 2021. And then on 14 May 2021, the trial chamber dismissed the defence motion alleging defects in the form of the amended indictment. On 1st April 2021, the trial chamber issued a decision instructing the registrar to appoint Mr. Altit as Mr. Kabuga's counsel under the Mechanisms Legal Aid Scheme until further order of the chamber. The trial chamber is seized with litigation related to counsel's remuneration, which will be adjudicated shortly. Turning to Mr. Kabuga's health, the trial chamber has received regular medical reports from the detention unit's medical officer since Mr. Kabuga's initial appearance. Recent reports following Mr. Kabuga's hospitalization in early February 2021 suggest that it is not presently appropriate to transfer him to Arusha for trial. On 15th April, the trial chamber ordered that an independent medical expert should examine Mr. Kabuga and submit a detailed written expert report. The expert originally appointed by the registrar had to withdraw due to unforeseen circumstances. The registrar should be commended for quickly finding another independent medical expert who agreed to his appointment on Friday the 21st of May 2021. That expert's report is due to be filed on Monday the 21st of June. Earlier today, the trial chamber dismissed Mr. Kabuga's request for a stay of proceedings or alternatively provisional release based on medical grounds for reasons which are set out in our written decision. I would now like to turn to the parties again and remind you that the purpose of a status conference is to facilitate exchanges between you and with the trial chamber so as to ensure expeditious trial proceedings, to review the status of the case, and to provide an opportunity for the defence to raise issues in relation to these matters, including the mental and physical condition of the accused and the conditions in which he is detained. Should it be necessary to cover matters of a confidential nature, counsel should so indicate when the proceedings must go into private session. However, as far as this chamber is concerned, we are anxious that the maximum extent of the proceedings should be in public, and counsel should feel restrained in making their motions for private proceedings and confine them to circumstances which clearly require that. So, turning to the parties themselves, firstly, to the prosecution, I would like to hear from the prosecution about the steps taken so far to ensure timely disclosure of exculpatory material to the defence in light of the trial chamber's instruction on this through the closing order of the 6th of April 2021. Will the prosecutor please address that issue?
Your Honours, the situation concerning our disclosure of Rule 73 exculpatory material is as follows. First, we fully understand the disclosure of exculpatory materials to be a primary obligation for the prosecution, and we are devoting significant resources to reviewing evidence collections for relevant material that may contain exculpatory information. This process is ongoing, but we are making good progress using searches related to the indictment and also to witnesses we have identified as possible trial witnesses. Since the last update in the written proceedings in lieu of the previous status conference, we have continued to disclose regular batches of potentially exculpatory documents found during this review. We have also been able to indicate where material is non-confidential, and we will continue to review how disclosed materials have been classified. We expect this review process and the attendant disclosure to continue during the pre-trial phase, and we can already alert the defence that a next batch of materials will be going out in the coming days.
One thing not clear to me, Mr. Elderkin, from that is to what extent has exculpatory material, potentially exculpatory material, actually been disclosed so far?
We have, and I will be corrected by my case manager if I am wrong, run to batches of totaling, I think, 90 unique items of disclosure disclosed in 3 batches up through the 21st of May of Rule 73 exculpatory material. And these have been generated, as I say, by applying searches across our evidentiary databases. We have picked what appear to us to be the relevant words from the indictment to run, otherwise the volume of material would swamp us. So we're generating large sets of material that then we are going through, obviously, with a very open approach to what might have the slightest hint of exculpatory character.
Now, you'll appreciate, Mr. Elderkin, that when we turn later to the work plan, that it is important that the disclosure obligations are implemented in keeping with that. It's a vital element in the pre-trial phase. Can I take it that, having regard to that, you're satisfied that the progress is timely so far?
Indeed, Your Honours, we have assigned a large proportion of our team's workforce to the review process. We have, in the beginning, come across some technical obstacles to running appropriate searches, but they now seem to be ticking along nicely, and at least at the rate of progress through the selected search terms, we are on course to finish these types of review and the attendant disclosure around the same timeline as indicated in the pre-trial work plan. Obviously, as new materials come in, we still have investigative activities ongoing, and these are always going to be subject to our review for anything potentially exculpatory. So there will normally never be an end to the process, but in terms of covering what we have in-house in a coherent way, I don't think that that is at all out of step with the timeline that has been proposed.
All right, thank you. Now, Mr. Altit, do you have any comments to make on the way in which you perceive the prosecution are going about the task of ensuring disclosure of exculpatory material.
Mr. Altit, thank you, Your Honor. On this point, if I may, I will give the floor to Mrs. Nauri, who will reply.
Are you happy? Just before we hear from Mrs. Nauri, you communicated with us indicating that she was likely to make certain submissions. Is this the subject matter on which she will be making submissions, or are there other matters that she will submit?
Mr. Altit. Well, there will, in all likelihood, be one or two topics on which she will take the floor.
Just give me one moment, would you? Would you want to raise this? Do you want to discuss it? The one point I think you should make clear to us, Mr. Altit, is the basis of the qualification of Ms. Nauri to make submissions in this court. As I don't think she's listed on the list of counsel who are presented to us, and so therefore, if you could. Indicate her qualifications for the role that you're inviting her to play in this proceedings. I think we would welcome that clarification.
Merci, Monsieur le Président.
Mr. Altit, thank you, Your Honor. If I may, very briefly, as we indicated in writing, and in the light of the fact that we are a small team, as you can see, there are only 3 of us, it is important for everyone to be able to contribute. That's the first thing. Secondly, Mrs. Nauri was co-counsel in a significant case at the ICC. She's lead counsel in the ICC. She's the vice president of the ICC bar. And she also plays a significant role here, as you can easily imagine. So we're in the process of dealing with all administrative matters for her to be able to submit. But in light of the urgency, we felt that it would be useful both for your chamber and also for the defense team to allow her to submit even before all formalities have been dealt with.
Thank you, Mr. Altit. We are content that Mrs. Nauri should make these submissions. Please continue, Mrs. Nauri.
Merci, Monsieur le Président. Mesdames.
Mrs. Nauri, thank you very much, Your Honor, Your Honors. Now, to reply on the issue of exculpatory evidence, we noted the information submitted by the prosecutor today. We'd like to specify the content of batches that we have received. For instance, on 20th of April, the batch included 19 elements. And on 21st of May, there were 7 elements. In other words, these are small batches. And we now need to analyze inculpatory evidence, and in the light of the exculpatory evidence, and of course we do understand that it may be necessary to do searches in a large database, as was pointed out. But that being said, We are slightly concerned as to the number of elements to be communicated or disclosed of an exculpatory nature, especially in light of the schedule. So as we go by, we're going to wait for new exculpatory material, but at the current pace, we'll probably get back to the trial chamber. Maybe we can discuss it ex parte with the prosecution to see how these can be accelerated. But we just wanted to update you regarding this, the disclosure of exculpatory material. Thank you.
This is something that the trial chamber will have to consider a bit further, because we need to be sure that the progress is adequate, and therefore the suggestion of further discussions between prosecution and defence is welcomed. But it may be that following this hearing today and the opportunity that the trial chamber will have later today or tomorrow to review these proceedings, that we may well give directions in relation to this matter. So for the moment, there's nothing more to be said on this, but there will be undoubtedly further exploration of this issue. Now, on the same, in the same area of activity, a request for access to confidential materials was made by the defence, and on the 21st of April, the trial chamber granted the request for access from related cases before the ICTR. The prosecution filed its notice of compliance with this decision yesterday, and we've reviewed the comments contained therein, but have only really had time to do that in a cursory way. However, does the defence have any comments to make on that, on the notice that was submitted to the trial chamber yesterday?
Oui. Avec votre permission, monsieur.
With your permission, Your Honor, Mrs. Oriva will also take the floor for this point.
Monsieur le Président.
Your Honor, on this particular point, we took note of the discussions that are taking place, and we have to analyze, of course, this, but the only comment that we would like to make is the following. When the defense will have had access to the elements, we will analyze those elements, that proof, and perhaps we will ask some additional elements if we identify the need for additional elements in this strategy. Our approach, in order to, of course, save time, would be it would be better, of course, to examine all the documents, and then we can only go back to the chamber, and we will look at the connected proof. So, of course, we looked at it yesterday, and we believe that this is the right procedure, the right way to do things. Thank you very much.
Do I understand then, from what you say, that you are satisfied with the way in which this has been addressed by the registry with the assistance of the prosecution?
Your Honor, yes, for now we are satisfied with the exchanges that we had. Of course, we don't have all the details, considering all the documents, but that's normal. But the only thing that we would like to say is that we adhere to this broader version because then later on we will not have to go back and ask to get some additional elements that we may have identified with respect to our vision in the defense and the way we treat this whole issue. Thank you.
I take it, Mr. Elterkin, that you have said what you have to say already in this notice that was submitted yesterday.
Your Honours, yes, but I believe there is one very short point raised in the notice that actually may be of more significance than it would appear on its face. Our final paragraph in our notice relates to public session transcripts, which naturally would fall beyond the remit of the access decision to confidential materials. What we've understood from our own observations of material that is actually available from ICTR archives is that there appear to be many transcripts that have all the characteristics of being public transcripts that somehow have ended up in the pile of materials designated as confidential. So as such, those are materials, as we say in our notice, that we did not give full review to because they're beyond the remit of the order. As we say in our notice, the defence should absolutely have access to all such materials, but it is not clear for me from a technical perspective whether or how they might actually achieve that access. Otherwise, yes, everything that we have to say in relation to our review for any potential IRMCT Rule 76 / ICTR Rule 70 review, that is as presented.
Well, that's actually a helpful comment, and the Chamber will be able to review what's been said, but my understanding is that there's general satisfaction at the moment with the approach being taken. The defence hope to be able to work with that and to limit any need to return for further order from the Chamber. And the Chamber will take note of what Mr. Elderkin has said and consider whether there is anything else that needs to be done in the circumstances. Now can I turn to the one formal document that was submitted to you in preparation for this, and that's the draft work plan. That was shared with the parties on the 28th of May. The draft considered the prosecution's positions expressed during the written procedure status conference, where the prosecution set out its proposals in relation to the timing of its pre-trial obligations. The Chamber has revised the prosecution's projections to periods or estimated periods that the Chamber considers more appropriate given the specific circumstances of this case. Now, Mr. Elderkin, it may be that you're content to leave matters the way they have been proposed and for an order to be made with the plan as set out in the annex to the draft, or alternatively you may have comments to make on it. What's your position?
Your Honours, we have no objection in relation to the deadlines indicated for the prosecution to fulfil the various pre-trial obligations. We will await the confirmation that the draft plan is adopted. I would like to note that we are still obviously living in a world where we face the unusual challenges of the ongoing COVID-19 pandemic. However, current circumstances are factored into the OTP's work planning in case of any unforeseen developments during the coming couple of months, the period of our pre-trial preparations. We will bring this to the Chamber's attention at the earliest opportunity. Otherwise, thank you very much for the proposal, and we don't have any other comments.
Thank you. Mr. Altit, do you have comments to make on the draft work plan?
Thank you very much, Your Honor. First of all, the defense took note of the commitment of the prosecution, an obligation. We completely understand the difficulties that may arise, and obviously, we also are fully aware that this is no small task. With respect to the mentions when it comes to the work plan, the tasks that the defense should carry out, namely the date of the 11th of October 2021, we have noted that date when it becomes to the submissions pursuant to Article 79F. In order to be able to meet that date, everything will depend on the memoir that the prosecutor will have to deposit on the 23rd of August. And it is indeed only after analyzing the pre-trial document, it is only then that we will be able to have an idea of the points that the defense wishes to challenge. When it comes to an eventual alibi and the special defense, it is quite possible that we request a delay because our response will depend on the investigations that we will have to lead. When it comes to those investigations, I would like to remind you that it is very difficult for the defense to investigate, particularly in Rwanda. Everything is extremely complicated, especially when it comes to maintaining the safety of people who could be potential witnesses or who are deemed to be witnesses. With respect to the information on expert witnesses, I see that there's a date of the 22nd of October in the work plan, and of course that will all depend as well on the brief by the prosecutor, and also to see which experts they intend to call, and also it will also depend on the investigations carried out in the field. If there are some difficulties, we will come back to the Chamber, to you, Your Honor, to inform you of it. That way, the Chamber will be kept abreast of the situation. If I may also seize this opportunity, Your Honor, Your Honors, to remind Your Honors that the defense is in a very difficult situation. Obviously, the prosecution had many years to build a case file. They had many years to do so, but when it comes to the defense, we are faced with difficult investigations on the field, but we are also faced with the COVID-19 epidemic, And it is very difficult to carry out investigations in that context, in the context of the pandemic, and with a small team. So that is one point, but I believe that that point is quite important, and I would like to ask you to take that into account. We will, of course, do everything we can, but we are facing some challenges, and we would like to ask you to kindly take those challenges into consideration. My second comment is a more general one. We have to analyze each element, each proof individually, but we also have to analyze everything by taking into account all the proof. And that is a major endeavor, and it is only after that we will have analyzed all the elements, it is only then that we can take the proof of the prosecutor as a whole, not element by element, but it is only then that we will be able to decide the strategy, to have a definitive strategy. For now, we have a provisional strategy, and it is only then that we will be able to deploy our strategy. What I wish to say by that is that there are some stages that we have to cross one by one. And there's also time. We need time in order to do our work correctly, and we have to respect that time. And it is only after we will have arrived at the end of that work that we will be able to say, this is what we have done, and we can answer some of your concerns and questions. Obviously, for any other questions, we can answer before, give you a response before that, but I just wanted to tell your honors that we are facing great challenges in the current conditions, and I just would like to assure you that we are going to do our best to do things as best we can and the fastest we possibly can.
For the assurances of parties that every effort will be made to meet the projected timescale for the preparation of this case and thereafter its conduct. We do recognize that we live in unusual times in certain respects, and the trial chamber will reflect that in any decisions it ultimately makes should particular points be raised with us. You can rest assured every consideration will be given to the submissions you may feel you have to make about difficulties that you face. However, I think we would also wish to emphasize the importance of very quickly endeavouring to come to terms with the problems that you do face, that postponing or delaying any activity in a case that is as old as this is something that will meet with no sympathy from the trial chamber. So we take heart from the submissions you make about the determination of both parties to try to adhere to the work plan. And with that in mind, I urge you to put or make every endeavour at this early stage to make as much progress with your preparations as you possibly can. I hear what you say about your small team, Mr. Altit, but any issues relating to that and difficulties that you may face ought to be addressed by demonstrating the problems in detail. I'm not expecting you to do that now, but I would expect that if the size of your team and the resources available to you are causing problems for you, that these will be brought to us at a point at which we can do something meaningful to ensure that the projected program doesn't fall behind. So we look to you to make any difficulties clear to the registry and to the trial chamber. Meanwhile, I feel a degree of optimism from listening to these submissions that you will be able to make substantial progress towards trial in what remains of this year. Now, can I have some guidance from the interpretation booth about the need or otherwise to break at this point? Silence.
We can go for another 30 minutes.
30?
Yeah.
All right. Thank you. Well, I'm assured we can proceed further at this stage. So can I now turn to the question of Mr. Kabuga's health and the conditions in which he is detained and any relevant associated circumstances. Mr. Altit.
Merci, Monsieur le Président. J'ai bien entendu.
Mr. Altit, thank you, Your Honor. I heard what you said in the beginning of the hearing. Wouldn't it be a right moment to move into private session, please?
Do you have any comment on that, Mr. Elderkin?
No, I think that's appropriate. Thank you, Your Honour.
Now, can that be achieved instantly?
We're now in open session, Your Honour.
Thank you. Mr. Elderkin, I've exhausted my agenda. Is there anything that you wish to raise in addition to that agenda?
Your Honour, there is one matter that was touched on in the written exchange in lieu of the previous status conference concerning certain disclosure and the language of that disclosure towards the defence. And I'm particularly referring to witness-related materials subject to Rule 71A2 disclosure. The stance of the prosecution up until the past week has been to gather existing material from our intended witnesses in Kinyarwanda, where that already exists, and we have been requesting translations into Kinyarwanda. At the same time, we have been engaging in inter partes discussions with the defence team. We know that their working language as a team is French. Their preference is to receive the disclosure of witness-related materials in French. While we don't have the resources and translation capacity to go back and request retranslation of the materials that we already have in Kinyarwanda or that are currently in progress, we have, on agreement with the defence, we will be going forward requesting that these materials, if necessary, be translated into French if they don't already exist in French. That's something that seems to be the most practical solution to the issue that was indeed indicated in the 6th of April order, and we hope that this will in part expedite some of our disclosure obligations. I'm sure that the defence will confirm if I have misstated anything that was agreed, but I understand that this seems to be the way forward.
Well, let me see if I've understood this correctly. In future, rather than Kinyarwanda, you're proposing to disclose material in French, are you?
So, Your Honour, we're talking about the set of witness-related materials.
Yes.
We have been gathering, obviously, these materials as we determine who are our set of witnesses to present at trial. Where we already have existing materials that fulfills the language requirement because it exists in Kinyarwanda, we are not proposing to have that material translated into French. We have also, some of this material is in process. For example, translations from English of statements taken have already been sent to Registry Language Services to request that they be rendered in Kinyarwanda. As of our discussion last week with the defence, any such requests going forward, we will be requesting, for example, a statement taken in English of a witness we intend to use at trial. We would request that that be translated into French. Where the witness materials exist currently in Kinyarwanda, but we also have a French version, we will of course be providing this to the defence. As far as possible, where materials exist, we will provide them in more than one language, but we can't find the resources at this stage to be directing translation to go both towards Kinyarwanda and towards French. So we're making a switch, essentially.
Mr. Altit, is that your understanding of the situation, and is it acceptable to you?
Oui, Monsieur le Président. Et
Yes, Your Honor. And we are very happy with the cooperation that we have with the prosecutor on many questions. Thank you very much.
Right, thank you. Now, the trial chamber will adjourn fairly briefly just now so that we can ensure among ourselves that there are no other issues that we have overlooked in light of all we've heard this afternoon, and whether there is anything else that we wish to discuss with you. But please do not go anywhere meanwhile. We should return fairly quickly.
All rise. Oui, vous levez.